Welcome to Notable Approvals. I am attorney Amanda Shaffer. Before I get to our case today, a quick reminder, don't forget to like us and follow us on Facebook, YouTube, Instagram, wherever you are watching. If you find this video to be helpful or know someone who may, don't forget to hit that share button. I also wanted to say, keep your eyes out because in the next couple of weeks, we will be launching a new website, a new rebranding, a lot of exciting stuff coming up in the next couple of weeks. So keep your eye out for that as well. Now, oops, sorry, I was fixing one of the cameras and blocked the other. So I'm really excited about this case. Now, if you're interested in O-1 visas, this is a case you want to hear about. I'm going to go through a lot because there's a lot of history here too. So stick with me because you'll learn a lot. But buckle down. We're gonna go through a lot of different things here, and this is a very interesting one. So this is a client who is a native and citizen of Russia, currently living in Prague. We actually filed an O-1A visa for him in 2015, and it was approved in 2016. However, his plans changed, and he never ended up actually getting the visa and coming to the United States. 8 years later, his plans changed again, still with the same company, and he's ready to come over. So he called us up, wanted me to refile. And you may say, oh, that sounds easy. You just take your old filing, you tell them it was approved, and then voila, you get another approval. I wish that were the case, but I will go through how he handled it. But first, let's talk about the requirements for an O-1A. So you either have to have won an internationally recognized award like the Nobel Prize or an Olympic medal. That's not an O-1A. That's an O-1A or an O-1B. I'm getting my O's confused. The only difference is the type of category. So B, I know, is artists and filmmakers, things like that. Science, that goes with O-1As. Regardless, major international award. If you want a major international award like the Nobel Peace Prize, fantastic. That's pretty much all you got to do. If not, you have to prove that you have at least 3 of the 8 following categories that you have. So 1 is a national or international prize or award for excellence in your field of endeavor. And we'll talk about what that means, field of endeavor, shortly. 2, membership in an association where the field is sought that requires outstanding achievement of its members. What this means is, I think the best example that I can give is if you're a lawyer and you're a member of the New York State Bar, all you have to do is be a lawyer in New York State, done all the same requirements that every other lawyer in New York State has to do, and pay a fee every year. There's no special requirements other than that. And that's true for every attorney that wants to be a member of the New York State Bar. So being a member of that organization doesn't mean that the requirements are that you be outstanding. So that's not going to get us very far. It has to be an organization that's like very selective. So there are some organizations out there, I know for attorneys, that you need like 20 years of trial litigation experience and they only pick certain people. So if you were like in that type of organization, that would work for this category. Number 3, publish materials about you or your work in major trade publications, major media, anything like that. And it has to be primarily about you or your work, the article. It can't be like you just getting a mention. Number 4 is that you've been a judge either individually or on a panel of the work of others. Number 5 is that you have an original scientific or scholarly contribution to the field of endeavor. 6, that you have authored scholarly articles in your field. And again, it has to be professional journals, major media that it's been published in. And The next one, that you've been employed in a critical or essential capacity in a distinguished reputation. So going back to my New York State, my New York State bar example, being a member of the New York State bar isn't going to be anything special. Being the president or on the executive board of the New York State bar, that might do. So it's not just about, so sometimes membership might work in one way and not in another way for one or two of these requirements. And a high salary, that you command a high salary or remuneration in comparison with others in your field. So if the average in your field is $100,000 a year in salary and you make $300,000 a year, then you're going to probably have a good chance of satisfying that category. So in addition, you have to show that you are going to continue to work in the field of endeavor when you get to the US, and that based on the totality of the circumstances, you have risen to the top 1% of your field in the world. And it could be filed either by yourself. This is one of the few work visa categories where you can self-petition, or you can have an employer file for you. And in this case, the employer was the petitioner. Now, field of endeavor. That is, I mentioned earlier, a very important topic to talk about. You have to define for USCIS what your field of endeavor is. And so if you ask me, well, what do I do for a living? I'm a lawyer. And you could say my field of endeavor or field of expertise is being a lawyer. But if you make it too broad, and I'm trying to compare myself with every lawyer in the world, trying to show you that any random person is in the top 1% of lawyers in the world, is going to be a lot harder than it is to say an immigration lawyer, or a removal defense lawyer, or a family-based green card lawyer, or an O-1 visa lawyer. So it's up to you to define the field, and you have to be careful because you don't want to be too narrow with your field, but you also, you don't want to be too broad, but you also don't want to be too narrow. You can't make up a field just to say, well, I'm in the top 1% of my field because there's no one else in my field. It has to be an established field. So in this case, this client, the job title is CTO, or Chief Technology Officer. And what he does for a living, in a nutshell, is he's an iOS app developer. Now, when I first started working with these clients, part of my job, and this is key, if you're looking to hire an attorney to handle your O-1, your attorney does not have to be well-versed in your practice area or your field of expertise. Your attorney just has to be able to understand it enough to explain it to USCIS. No matter what you do, if you're a basketball player, a singer, or an app developer, you have to assume that the person reading your application doesn't know anything about your job. That you have to explain it to them in plain English. And that can be sometimes the hardest part. So in this case, you have a client that comes to you and says, I'm a software developer. And the reason that I'm special is because I can do what he called cross-platform development. So he is he knows all these different coding languages: C Suite, Linux, iOS, Android, Python, all that type of stuff. And he can code in almost any language. And that's why part of that knowledge is why his apps are so good in iOS, because, when you make an app, a lot of times it ends up not just being on one platform. So not just with Apple, but ends up on Google. It might end up as a website, whatever the case may be. So to be able to know a lot of different coding languages is a rarity, to know that much and that well, all of those different languages. It makes it so that your apps can are easier to adapt cross-platform, easier to adapt to changes, things like that. So that's how I explained it at first. And I think that it confused USCIS, because when I changed his field of endeavor to iOS app developer, everything seemed to go much smoother. And sometimes you don't know what it's going to be. I didn't know I thought that was too narrow actually at first, doing iOS app developer. And having a cross-platform developer, I thought, well, there couldn't be two, that might be narrow too, but it made sense based on what we were talking about and also based on the evidence, because although iOS and app development were his primary focus, he wrote about other things too, like other coding, and he did coding for all different things. So you got to work, of course, with what you have as well. So with the first filing, the evidence we initially submitted showed that he had original contributions to his field, published materials about him and his work. He was a judge of others and a guest speaker. And then we had letters of recommendations from experts in the field. There was no advisory group. So if you have a peer or advisory group, and USCIS on their website has a list of every group, basically for all different professions, you have to get a letter from them. I mean, if you're in the arts, for example, there are a host of different ones that you can, like the American Screen Actors Guild, you get a letter from them. In this case, we didn't have an organization we can contact, which honestly can make it easier. You just send them, their resume, body of work, and then they write a letter. But in this case, we couldn't. So we got other experts in the field to do that. And we didn't do premium processing, which is when you pay extra, and in 15 days, you either get a response or an approval, denial, or request for evidence, instead of waiting an indefinite period of time. So when we finally got the request for evidence for this first filing, it was massive. I was like overwhelmed by how much. Basically, they were saying we only proved one thing. They did, of course, ignore a lot of evidence that I had to re-point out, which is fine. But we had to do a little bit more than we did with the initial filing, and now we knew exactly what they wanted us to do. So the number one thing I did was explain his field of endeavor better. Not only did I say he's an iOS app developer, I also explained how apps are developed, how it works, and how important maintenance is. Like how, Apple will send an update, update your iPhone, and then all of a sudden the apps need to then incorporate those changes. They have to do it themselves. So I explained that, which made it much, I think, more understandable to the person reading it. Then I went through, I changed the way I did it. So we were debating, should I go through the categories I just went through one by one, so original contribution, salary, etc., and then say how the evidence fits into each category, or should I go by each contribution or each body of work and then explain which categories it fits into, because it did overlap a lot. I tried the first time I was, you always try, I know they have a checklist in front of them, so I always want to try to go by their USCIS's list. So the first initial filing, I went original contribution, salary, etc., and then I explained what the evidence was, and that's what the evidence list looked like too. This time around, when we responded to the request for evidence, we decided, why don't we go by contribution? So I would, for example, this client writes a lot of open source codes. He writes a lot of codes and puts on open source. So open source code means that you publish it online for anybody to be able to use in their own projects without paying you or citing you. This is very common in the programmer developer world. So what I was able to do was, like this one code he wrote, for example, there was a bunch of them that were huge, but one of them was the biggest one. So I explained that what an open source code was, and that it was downloaded over 300,000 times by other app developers. So these are other people in his field. And he used it also in his own app. And the app, one of the apps that he used it in to develop, had over 500,000 daily users. And there was also an article about the app that had an average of 7,000 readers a month. And if you're sitting there thinking, well, how do you know if those numbers are good enough? You don't always know if the numbers are good enough. It's hard to say because I want to be able, my ideal was let me find another code and that is big quote, and then you can compare the numbers that way. It's not always necessary. These are big numbers. They look like big numbers. So you kind of have to go with your gut sometimes on how far do you have to go to prove your point. In this case, I was comfortable that that was a lot. And not only that, this particular code, the client used a lot in his apps, and a lot of people wrote about how helpful this code was. So that was good. Then we talked about an app he developed that had over 300,000 downloads. It had 4.5 out of 5 on iTunes, and it had been featured as best new app and had one of those banners. When you open the app store, I know it's changed over time, but sometimes it features apps. It's been featured multiple times. Now, that one, you might be saying, well, I bet you not a lot of apps are featured, because I know that because I go into my app store and there's only one each day or every few days or whatever it is. There can't be that many. And you're right, there are not that many. And you might think, oh, well, you could probably stop there. No, what I ended up doing was I found out that, thank you, Ricardo. I saying hi. Thank you for watching. So I actually found out that only 0.1% of apps in the App Store ever featured, which is huge. It's a small number, but a big number. That's a big deal. So that's why I was a little less worried about some of the other numbers, because for each of these categories, you really only need one thing, but you want to show your body of work, because as I mentioned, it's the totality of the circumstances. So they look at everything. For published materials, that cites the client or his work. We had plenty of articles about him and his work in professional journals. So we had to get proof that the sites were legitimate professional journal sites. And that can be a little harder to do sometimes. One way to do it is you get experts in your field writing about it. Sometimes the website and the About Us section makes it clear. Sometimes it's another article that talks about it. It all depends. But even the US publications that we had, that you would, and I may think is just common knowledge, like this client was published in, or articles about him in PC Magazine, and CNET, and Engadget. For me, these are all well known. I know them. I mean, I'm a little techie, but even if I wasn't, people, you see that when you Google stuff, but you can't assume anything. So I had to go in and actually show that these websites, so these publications are a big deal. So for example, this was back in 2016, CNET ranked 166 website in the world, 76 in the US, with over 257 million viewers, which again, those are big numbers. Think about how many websites in the world exist, in the US exist, and there you go. For scholarly articles, and so these are articles written by the client or the beneficiary, it's the same thing. Anywhere that he's published, it's like I can tell them he was published 20 times in PC Magazine, but I then have to go and explain what PC Magazine is. I have to get the circulation numbers, daily, if it's a website, daily users, downloads, if it's something to be downloaded, things like that. So the RFE, a lot of our response for the RFE was really focused on getting these circulation numbers for all these publications and download numbers and things like that. For employment in the essential or critical capacity in a distinguished reputation, well, in an organization with a distinguished reputation, I had to, I said he's a COO of the biggest app that he had. And then we got that, and it was his code that was used to build the apps. And then we got letters from either the CEO of the company or the contractor, whoever hired him to build the app, to say that without this guy and without him using his code, or we would not have had this app, we would not have had the success that we had. And then as a judge of other individuals in his field, again, I had to get letters from the place where he judged to explain why he was chosen, like how, not just him, but how they choose judges in general, what did he judge, and like kind of explain the entire competition. So that got approved, and we did a great job. We were really excited. I'll admit I was a little bummed when the client didn't come to the US, but plans changed. I understand, because I was just excited he got approved, because this was, it was a hard one, just because a lot of the stuff were in Russian, and it was a field that I had a little familiarity with in the beginning. Now I could probably explain all this to you very easily. So then when they came back to us this year, a couple months ago, and said, he can't work in Russia because of the war. I mean, he literally, because of sanctions, you're not allowed to even get money from people. Communication was hard. He had been living in Prague, but they really wanted to grow the business in the US. And it's the same company. The petitioner is the company, same company. He's been working for them overseas because they have an office there too. And now they wanted to grow the business more in the US. And again, you might be thinking, well, you've already done it. All you got to do is submit the old one, maybe some new stuff, and you're good. Well, the problem is 8 years have passed since the approval. And fortunately, this client has done a tremendous amount since then. But you can't just sit back and say, well, we got this approved 8 years ago, so therefore we should get it approved again. That is not how immigration works, let me tell you. The tricky part this time around is we had so much evidence. It was like, what do I submit? Do I submit everything we submitted last time and all the new stuff? Or do I just submit selective things from the old and mostly new? How do we do this? Because if I would have submitted everything, it literally would have been, I probably am underestimating the size of this filing. So more is not always better, is kind of the point here, because you don't want to confuse them and you want to make it clear. You want to highlight the more recent things, but you also want to show that over time he's sustained, because it's sustained international acclaim, sustained top 1% of your field. So that means over time. So I had to make sure that I went through the evidence, and I picked out what were his greatest accomplishments in the past. And I took some of the evidence from there. And then I focused mostly on the newer stuff. And I was able to show easily 6 out of the 8 criteria. So for original contributions, again, I picked the best ones. I submitted some of the old evidence, but for the most part, I didn't resubmit anything. I actually cited to it. I said, this was previously filed with, the approved petition with receipt number, blah, blah, blah. We can give you that evidence if you want. And I knew that if they sent a request for evidence, we have the evidence already. For the new stuff, we had a new app that had over 1.2 million downloads, 4.7 out of 5 stars on the iTunes, now it's the App Store, with over 37,000 reviews. It also ranked 30th in the finance category in the App Store. Those are big numbers. Again, what am I comparing it to? Well, even if you compare it to the app I talked about earlier, it's a bigger number. But the important part is 37,000 reviews can't be denied. And having a 4.7 out of 5 is huge. And this was a finance app. So that was a really good one to highlight. The client had also created additional source codes and published those online. So we talked about the new source codes. And we knew that this time around, we had to also talk about where it was published. So he only published it on these websites. There's a couple of websites that programmers and developers primarily use. And they all go to and they put their codes and people update them and they collaborate. And And this is how the community is. So this time around, I was able to put in the circulation numbers or the daily user numbers, knowing that they were going to ask for it. Oh, and I forgot also the app that I just mentioned, it also won multiple national awards. So we put that in too. And again, even though I'm going by category right now, when I made the exhibit list and the cover letter this time around, I went by the app or the work body of work or the contribution one by one instead of category by category, and explain which category it fell into, which seemed to be, at least in this case, every case is different. In this case, it was definitely the way to go. So then we had expert letters as well that talked about these new contributions. For the scholarly articles, we referenced one site that's this really big with programmers and referenced the past petition and didn't submit anything new. For published, we also did published conference presentations at national and internationally recognized events, and employment in an essential or critical role. He's the CTO of 2 major iOS app development companies. Both of the organizations and the apps they created have won multiple awards. So we were able to show that. We got letters from the CEOs of these companies about how important his contributions are. And that for one of these companies, we were able to show that they have over 354,000 users a month that visit their site, which is a big number. The question that's always going to be is USCIS going to come back to me and say, well, compare that to a random website. And you actually can do that, but it's a big number, especially for a tiny little company. And then we were able to show the awards, that he has multiple awards. When you do that, you have to show not just that you won the award, but what the criteria is for judging the submissions for the awards, how many submissions there are, how many people win, and who's judging it. Obviously, it's different if an expert is judging it versus a person off the street. And we showed that he judged the work of others. Again, we didn't resubmit it. We just referenced what he did in 2015. This time around, instead of doing regular processing, the clients wanted to do premium processing, which again, 15 days they have. So within 15 days, I don't know, I think maybe once, but every time I've done premium processing, they always send a request for evidence. And when they send you a request for evidence, so you pay extra for 15 days for approval, denial, or request for evidence. Rarely, I've never had one denied in the 15 days. It's either approved, which happened like once, which is usually request for evidence. Once they get your response to the request for evidence, they then have a new 15 days, business days, to respond. So that means it takes a little bit more time and is annoying. But this time around, instead of getting a massive RFE where they basically said, you've proved nothing, they only asked for one thing. And the weird thing was, the one thing they asked for was the one thing they didn't ask for the first time around. And that is, they asked for recommendation letters from experts physically in the US in the field. Now, we had a bunch of expert letters that we submitted, and none of them were located in the US, but some of the companies were, but the address they put wasn't. And I looked back at the old petition, and I realized that when we did the old petition, none of the experts were actually located in the US, but for some reason they didn't ask for it this time. And I'm pointing this out because this is a great example, because a lot of times people come to me and say, well, this worked for my friend, why won't it work for me? Or this worked last time, why won't it work this time? Very simply put, immigration makes mistakes. Did they make a mistake this time, or were they just giving us a hard time, or last time, or were they just giving us a hard time? It doesn't matter. It matters that this is, now if they were, I think I had looked it up and it said, I don't remember if it said US-based person or a US-based company or whatever it was, but it wasn't worth arguing over because we knew it was going to be easy to get and it was only one thing we had to get. But the whole point is that I couldn't just resubmit the old petition because you have a different person looking at it. And not only do you have the problem of the time period that's passed, you also have the problem of that two people may review the same thing, and one person might approve it and one person may not. So you have to keep that in mind whenever you're filing something. And you have to remember that even your own case you can't depend on, if there is a mistake that happened, you can't depend on that mistake happening again. And people run into these problems all the time, you see. So we were able to get 5 letters from people in the US, and we had to have in the letter, they had to explain how they were an expert in the field, what they reviewed, so what they made their judgment based on. So some of them knew the beneficiary personally and also reviewed his body of work, and some didn't know him but reviewed his body of work. And then they had to say if they thought this was a person of extraordinary ability as an iOS app developer, and if he is the job that he wants, is applying for, does that require a person of extraordinary ability? And then I had to sum it all up for USCIS. So I took all the letters, I put in a nice little exhibit list, and then in my cover letter, I explained this person is a professor at blank in computer science, and we had made sure, because there's no professors of app development, he wrote app development is a part of the computer science field. So we send it in. Oh, and I also included 3 letters from the previous application, just kind of a little out of spite, because I was annoyed, because I was like, these were fine, and last time so they should be fine again, So when you're doing premium processing and you're applying to a request for evidence, you have an option. If your response is under 25 pages, you can fax it or you can mail it. Now, because this premium processing lockbox or office is in California, my clients, we wanted to fax it. And now I told them, our response is 23 pages, so we can fax it. Now, the request for evidence, even though they only asked for one thing, was actually 3 pages. And in the instructions, it says, however you submit your response, you need to put the request for evidence on top, which we always do. So when you put the request for evidence on top, it became 26 pages. So in the cover letter, I explained our response is 23 pages. The request for evidence is 3 pages, and this fax cover page is 1 page for a total of 27 pages. And premium processing is supposed to be like this. Like you fax it, they say we got it, and and then you get a decision pretty quickly. So a day goes by, 2 days goes by, we hear nothing. And I did make sure I had that the fax went through. I got the confirmation. So they also have an email address that you can email about. And they're pretty responsive. So I emailed them asking them if they got our fax, and they didn't respond. So my client's like, can you call them? And I was like, no. If anyone watching has ever called USCIS's customer service line, you know why I said no. And this client also now knows why I said no. And the main reason is he's spent hours waiting. And then when he finally got a live person, which is not easy to get, they said to him they could not confirm or deny receipt of our response to the request for evidence, which blew my mind. It's a fax. So at least it spurred them to email me back, I think. They said, can you please send us, and by the way, when I emailed them the first time, I emailed them a copy of the the successful fax receipt, and I also attached the PDF of the response. So they write back to me and they said, you didn't attach anything. Can you send us the attachment again? Or can you send us proof that the fax was received or went through? And then I looked down at the bottom of the email, seeing my attachments there. I'm like, okay. So I send it to them again. Silence. Basically, we had to follow up with them again. It was maddening. My client was like, should we just mail it? And I'm like, I want to, but if we mail it and they realize they have the facts, then they get confused, and we don't want to have an issue because there's a double submission. So, there's like your head is going crazy here because you want it to get decided fast, but you also don't understand why are they not responding or acknowledging receipt. So finally, we get an email from them saying that the application has been sent for adjudication. So I said, well, I wrote them back, are you confirming receipt of the response? Because that's not confirming receipt. That could be you're not going to respond, then we're just going to send it to adjudication. So they confirmed, yes, we received it, and the response has been sent for adjudication. And we were like, good. I mean, we had plenty of time. We had till October, but again, he wants to get here. Like we're trying to get this done. They're losing business left and right. So we kind of all took a deep breath and or let out a deep breath, and we went on to other things. Clearly the story isn't over, because a couple of days later, they write back saying, your response was over 25 pages. You need to mail it. And I was so angry. I was so angry because number one, our response wasn't. It was 23 pages. And by the language of the request for evidence, the actual request for evidence, those top 3 pages did not qualify as part of the response. I could have argued with them, but this is, you got to pick and choose your battles with USCIS. This was not one when you can easily just mail it out. It's not like we were worried. If we were worried about missing a deadline, that's a different story. But I was just so mad because here I thought it was all done and I didn't have to worry. And now I'm angrily printing out 26 pages and, overnighting it to them. So it is a lesson to be learned that if you're going to fax it on premium processing, they're going to count. You have to assume, at least, because a different person might not have counted it as over 25 pages. Assume they're going to count the top 3, the cover page, I should say the request for evidence itself, which you have to include as part of your 25 pages. So we mailed it out, and literally that day it was approved. And actually found out last night at like 8 p.m. because California time, they're 3 hours behind us there. So now the case is being transferred to the National Visa Center and then to the embassy abroad. Right now, the client's in Prague, but the backlog in Prague has because of Ukraine. So we're going to try to transfer him to Israel or another consulate, because right now, if you're Russian, they're not making you go back to Russia because there is no way to get a visa in Russia right now. There's no diplomat, there's no staff at the embassy. So we're trying to get this client here again as fast as possible because of the business really needs him here. And he really needs to be able to have the contact with the U.S. clients easily. So this case, I know this was a long one. There was a lot here. If you are thinking of applying for an O-1, whether it's an A or a B, I highly recommend rewatching this, thinking about all the different issues, because we are very good at evaluating eligibility for O-1s and EB-1s. They're very similar. EB-1s are the immigrant visa version for an extraordinary ability. It's what leads to the green card. O-1s don't lead to a green card, but can be renewed. So we're very good at evaluating it. And like this client from day one, it was clear that he was going to be eligible, but the hard part was proving he was eligible in a way that USCIS understood. So the more you do, different professions require different things to show. It's never the same. And even, between this filing and the last filing for the same client, for the same job with the same company, we had to submit. So it's really interesting in that respect. And then I learned I am never faxing again. And I don't even know why people have faxes anymore. We don't have a fax. We have like metrofax.com, which is like, it's all online. So I'm basically faxing through the internet. And I'm pretty sure they have a regular fax machine on the other end. Why we couldn't email it to them is beyond me, but you know, it is what it is. I'm hopefully soon we'll be able to do that. But keep that in mind. If you're doing premium processing and you respond to requests for evidence, the request for evidence pages count towards your response number of overall pages, even though it probably shouldn't. But we are thrilled for this client, and we've already contacted the embassy. We're going to try to get him here really as soon as we possibly can. And he, I believe, is going to make some great contributions in this country, as he already has. So that is all today for notable approvals. If you found this video to be helpful or know someone who does, please. Oh, I'm looking weird on Instagram because someone's calling me. But oh, that's so weird. If you're not watching the Instagram feed, you should see what's going on right now. If you guys can see it, it's weird. I can't explain it. Anyways, hit the share button, especially if you know someone looking to apply for an O-1 or an EB-1 visa. And don't forget to like us and follow us on Facebook, YouTube, Instagram, wherever you are watching us. Don't miss any of our lives. And this will also make sure that you don't miss out when we announce our new website, new branding, and some new exciting things that are coming through the woodworks. We want you all to see that. And I will see you next time. Notable approvals. Thank you all for watching and have a good day.